Ms. Cox, this is your uncle.
Yes.
And who are you?
I'm Joe's wife.
Your grandmother, your mother, passed away.
Yes.
According to your complaint, your grandmother, with whom you enjoyed a lovely relationship, promised you
Her vehicle, of whichever it may be when she passed away, which is a 91 Thunderbird.
When did she make this promise to you?
This was, she had an 88 Thunderbird, I think it was 88 or 89, which my other aunt had received, and at the time I just turned 16, and she promised me then the white Thunderbird, which went to my aunt who has children and needed a vehicle. So she always promised me that she would leave me her car.
You must have had a hot grandmother. She liked Thunderbirds.
Yeah.
So she passed away recently. According to your complaint, the only signed will makes no mention of that bequest.
No. It was also done in '77.
Could I bring up something, Your Honor?
You, sir, are the executor of the estate.
Yes, according to the signed will, yes.
And is there another will, sir?
Yes. This is a will that we received from a attorney that said that from the discussion I had with my sister, Deborah, which is Wendy's mother, that he had told her that...
Just, you can't tell me all these things. This is all hearsay. You received another will.
Yes.
That is unsigned.
That's the will.
Okay, and this was executed in 1992.
Yes.
All right, let me understand this. We have a 1977 will which makes no mention, that is signed.
Yes.
And makes no mention of this car bequest. Then you have a 1992 will, which according to the plaintiff does discuss the car.
Yes.
Let me just take a look at it. Mr. Taglavor, were you satisfied that your mother had, in fact, in 1992, had a change of heart, despite the fact that you didn't sign this will?
Yes, I didn't know it. Yes.
Could you sit down, please? Just sit down. The answer is yes. Evidently there was some dispute that your mother had with somebody else, and she, in fact, changed her will.
Yes.
But did not sign it.
As far as I know.
As far as you know, didn't sign it.
Right.
Is there anything that you know about that I haven't said yet?
Yes.
Go ahead.
In the hospital when my grandmother was dying, my husband, my mother, my uncle Bill, and her other son, and my mother, the executor on the second will, she was telling us that her phone book, bank receipts, her will, stuff for her funeral, everything was in her briefcase. We found everything except for her will, which then in her phone book, in 2 different spots, it is noted, Opendahl, the one that drew up the second will, is her attorney has her will. That's how they found him. This is her phone book.
It says in that, attorney has will.
Has will.
Fine.
And I also have a letter from the attorney saying that he was the one that drew it up, and no, she never signed it, that it was her right to be able to take her copy with her, and it was up to her.
Ms. Cox, so then what I'm saying is accurate. Let's put
Yes.
this in order. We have a signed 1977 will, which you acknowledge does not make any bequest of this car to you. Were you
No.
born in 1977?
I was born in '76.
Okay, so you were a year old. She wouldn't have left you a car.
No.
Later, you both agree that your mother and your grandmother had the intention of changing her will to leave you the car, but she never fully executed the will, which means she did not have it signed and witnessed. That's according to you, madam, because you just told me that in her papers, in her book, it says attorney has the will. And if this is the will that you got from the attorney, it is unsigned, correct?
Yes.
Right?
Yes, ma'am.
So here we have the problem.
This is a copy of the will from 1977.
I'll take a look at it. Mr. Taglavor,
That's where
listen
I got
to me.
the address.
Listen to me.
Yes, ma'am.
I think you were very honest with me a moment ago. I assume that you love your mother and you know in your heart that she may have not been good at executing this 1992 will, but that was her intention, that your niece have this car.
My mother spoke to me in '96 in November.
Who are you?
I'm her daughter also. She called me in Kentucky, was calling me, and I brought up my will, she brought up her will. Nothing was ever mentioned. She said, I have 6 kids, if there should be anything left, we divided equally. Nothing was ever mentioned once. Wendy didn't know, none of us kids knew that this other will existed. Mom never mentioned to not a one of us.
Fine, but it does exist. How much property did your mother leave?
The automobile was it, basically.
If you went to sell, sir, a 1991 Thunderbird, how much do you think you could get for it?
5,000 maybe.
Maybe.
6, maybe. Depending on what kind of shape it was in.
Okay, well, what kind of shape is it in?
It's in very good shape.
Okay,
Low
so let's say,
mileage.
and there are 5 kids?
6.
6 kids. So let's make it easy for this old judge, because I'm not real good in math, as Bird can tell you. So let's say you can sell the car for $6,000. So everybody gets $1,000, right?
Right.
The laws in every jurisdiction require a will to be executed in a certain fashion. So we're talking here about a situation where the law, Ms. Cox, in this and practically every jurisdiction in this country requires that a will and any subsequent change of the will be signed and witnessed. Correct? On the other hand, we're talking about whatever is morally right with regard to this car. I believe that you two people know that it was your mother's intention for her granddaughter to have this car, for whatever reason. I'm sure she has a lot of other grandchildren, but that's what she intended, for this car to go to this grandchild.
Well,
We're not talking about a lot of money here, Mr. Taglavore. We're talking about at most $6,000 or $1,000 per person who would tend to inherit the money. So maybe we can come up with some way of being fair to your mother's wishes and also being fair to you, consistent with this will, which is unsigned.
Your Honor, I also
What?
have a letter from that attorney.
So what? I don't need the attorney. They don't dispute that. Ms. Cox, relax.
Okay, but
Relax. They don't dispute
no,
that this...
I was just wondering if that would be, I know it's not signed, I'm just wondering if he
No,
can't
I
be a
don't read
witness,
letters
can
from
he?
attorneys. If you want a witness here, you have to have a witness here.
Okay.
What I started to say to you is perhaps we can come up with something that is fair, reasonably fair to each side. Would it be fair for Ms. Cox to have use of this car until she decides to sell it, and when she decides to sell it, the proceeds of the sale of that car are distributed among the 6 of you? So that in some way, the last wishes of your mother would be honored. Would that be reasonable?
I don't know. I don't know what to do. You don't understand the whole story, I don't believe.
Well, I'll listen to the whole story.
This started years ago when my mother first told me. She told me, you make sure that you take care of your brother James, which is on that will.
In 1977.
Long before then.
But
If anything happened to her, she said, you make sure that he gets his share of whatever is left because he will not take care of it himself. The money would mean a lot to him. It doesn't mean anything to me. My sister, nobody else in the family, you know, $1,000, like you say, is not much money.
so
When you
what's
come right
James's
down to it.
problem?
He's like one step from homeless, pretty much.
Is
But-
there something physically wrong with him, or does he have an alcohol or a drug problem?
No, he's partially disabled. He lives on state aid and stuff like that.
So he has money from Social Security disability.
Right. Which is not much.
I understand that.
$1,000 to him is a lot of money. And this is a promise I made to my mother. And then when this thing all started, as far as I was concerned, I thought my sister was supposed to be executor of this will, and this was all taken care of. She comes after my mother passes away. All the children come to my house. They say, we want you to take care of this. I told Mom in 1995 I wanted to be taken off as executor of the will. I didn't want to have anything to do with it. This was all news to me. So I agreed to do it. Then we started searching and finding stuff. Now this has turned into a total nightmare, and I'm the bad guy when the only thing I say there that is legally binding is that I have to do what the signed will says to do. Now this is all the argument. This is all the bull that I have got from my family.
Sure, because
for doing what I was told to do by the law and asked to do by my siblings.
Well, you're right, Mr. Tagliavore. You, unfortunately, are placed in that responsibility because it's not just you, but you have 5 siblings that you have to deal with,
Right,
too.
and my sister Paula says there's another will that leaves her the car. An orthographic will that she cannot find witnesses to. There's wills floating all over this place. But
Listen,
none of them are signed
there are a lot of
except
wills,
for
but no
one.
property.
Right.
You know, a lot of wills, but one old
And there's
Thunderbird.
nothing but a car.
So I would assume that you cannot speak for your whole family.
Oh, no, no way.
Absolutely not.
Absolutely not.
Absolutely not. What do you want to say?
It's funny that Mother never said anything to anybody, not even to Wendy or Debbie. Nothing was said till after the funeral. I mean, she didn't say anything.
No.
Wendy never said
No.
anything.
Just a second. Who didn't say anything?
Wendy didn't say nothing. Debbie didn't say nothing. Mom never said nothing.
Listen
that she
to
wanted
me,
Wendy to have the car.
Listen to me, madam.
And I talked to her.
Listen to me.
Okay. I guess it doesn't matter. Whatever you want.
It doesn't. Let me tell you why it doesn't matter.
It upsets me.
Let me tell you why it doesn't matter. Very often when somebody is ill, or even before they're ill, when they are distributing their property by way of a will, and they don't want to create bad feeling while they're alive. They don't want one child to be angry with them or another child or a grandchild to be angry with them. They won't discuss what they're leaving in their will because they figure, when I'm dead, it don't make any difference. So they will not tell their children. Do you have children?
Mm-hmm.
You have children. Would you have felt badly when you spoke to your mother if your mother said to you, I'm leaving Wendy my only possession, my car? You would have been annoyed with your mother.
I wouldn't.
Sure you would have. And your kids and your children would have been annoyed. Why is Grandma just leaving? Is she the favorite? Why is Grandma just leaving Wendy the car and I don't get anything? Does that sound possible to you?
Well, if it's yes, possible. But if it was her wishes, Mom wasn't shy.
You don't. It's not a question of being shy. No. It's a question of not having your kids or your grandchildren annoyed with you while you're here to experience the feeling. Mm-hmm. Once you're gone, you're gone. Ms. Cox, you understand you have a problem.
Yeah.
And your problem is that even under the common law, which forms the basis of every law of every jurisdiction, a last will and testament was required to have some sort of a writing, at least signed by the, we call them the testator or the testatrix, that means the deceased. The only signed will that exists here that I see is one that was made in 1977. It doesn't make any mention of a car to you. Your uncle is not a bad guy. If he did anything else with this car, but do what it says to do in the original will, which is dispose of all my property equally among my children, he could be sued by the other siblings for a violation of his duties as executor of the will.
Thank you.
Do you understand that?
Yes, I do.
Well, that's unreasonable. That's unreasonable. I can't permit that to happen. My sense is he would like to do the right thing. But unless all of the siblings together say, you can turn the car over to Wendy because that's what Mom wanted, he can't do that. Do you understand? What I think is too bad is that if all the siblings understand that this was Mom's request, and all we're talking about really is $1,000 that you were concerned about for James, because that would mean a lot to him. Well, maybe. Wendy here would say, I'll give James $1,000, give me the car.
My mother, the executor on the second will, which my uncle is not even in.
There's no
Agree-
second will.
No, but
Wendy,
I know. Okay,
there's
but I'm
no
just saying.
second will.
All right, but my mom did agree to do that. My mom was willing to give my Uncle James $1,000 to make sure he was taken care of because she loves her brother. It has nothing to do with the Thunderbird.
This is a very good
For
lesson to everybody.
$1,000, this is ridiculous.
It's a very good lesson to everybody. None of us feel that tomorrow is our last day, so we all tend to put off taking care of business, which keeps things orderly and organized in our lives and prevents this kind of thing happening to a family. Usually when these kinds of things happen within a family, when somebody dies, you're talking about a lot of money. It's absolutely outrageous to me that this is doing this to a family when you're talking about a car, which is the only asset that your mother had. So people who don't take care of their business by keeping abreast of what property they have and how they want to dispose of it and making clear dispositions of that property before they die are not doing their families a favor. Morally, Wendy, I believe that you are correct that your grandmother wanted you to have this car. Legally, you cannot establish that to me. Moreover, I honestly believe, after speaking to your uncle, that if he had his druthers, he would give you this car. If it was a question of, listen, either the car is mine or it's Wendy's, he would say, you can have the car. He is not in that position. He stands in what we call a fiduciary relationship to his other siblings. He represents them. Unless there is a unity of spirit in that, among those 6 siblings, unless all of them say, give Wendy the car, despite the fact that that's not what your signed will says, he can be sued by them, and it ends up costing him $5,000 or $6,000, probably more with attorney's fees, because he'd have to hire an attorney to defend himself, and you would maybe get the car. So don't blame him. It's not his fault. It's really, unfortunately, your grandmother's fault, because she did not take care of business when she could have in 1992 by signing this will and having a fully executed copy. So this lawsuit is dismissed. Thank you.
This case is about a family fight over a car. Jack Judy said she believed the grandmother may have wanted Wendy to have the car, but there is no proof in the will. The uncle must follow the will, or the other siblings could sue him. In the end, Jack Judy dismissed the case. She also said people should make clear will the stop family fight.